Dear friends, in this video today we will see how to make an effective arguments before the courts, and I hope and believe this video will benefit all the young advocates who have started litigation as a practice in their career. Before going into the argument skills, an advocate should prepare a synopsis touching his litigation. Now, what are all the things which has to be included in the synopsis is the relevant facts of the litigation, the applicable provisions of law, statutes or legislation, and all circulars notification as applicable to the litigation, and which is followed by the precedent and authorities and the legal proposition of law which has been settled by the Supreme Court or any other judgments which has been delivered by the high courts. These three things has to be mentioned in the synopsis. Now, after preparing the synopsis, the advocate should focus on the typed set which he will be filing along with the petition. What are all the litigation submissions which are noted in the synopsis? All corresponding relevant documents in the typeset has to be clearly marked, and a color prop has to be pasted in the all the relevant documents in the typeset. And before going to the court, an advocate should make apprise of himself what he has mentioned in the synopsis, and it would be better and recommended that he has to memorize all the points which he has mentioned in this synopsis, and to take a rehearsal. It depends upon how many times an advocate takes it. It all purely depends upon the ability and the intellectual level and competence and skill of the particular advocate. But before going to the court, an advocate should well verse about those proposed submissions which he has mentioned in the synopsis before arguing the case. Now, on the date of hearing of the case, an advocate should not simply go to that particular court and start commencing the argument. Before doing that, one important thing an advocate is advisable to do is he should go and observe the court proceedings of the concerned portfolio judge to whom the litigation will be listed for arguments. Once he goes to the court and he observes the proceedings conducted by the learned judge, that will give him an input how the judge conducts the proceedings, to observe his working style, to observe his interaction with the learned advocates who are arguing the case, and what kind of approach the judge is having with the counsel's interaction. This will give an outline to the advocate what he should do and what he should avoid while arguing the matter before that concerned judge. It will give a first-hand experience. After having some picture about the way the judge conducts is court litigation proceedings. Then on the date of hearing, the advocate should go early to the court before the hearing commences, so that he will be accommodated to the atmosphere and environment of the court hall. Once the matter is called, here an advocate should have and possess self-confidence, and he should have the guts and courage to stand and rise to the occasion to present his case effectively and efficiently before the learned judge. The first and foremost to commence the argument is start from narrative of the relevant material facts of the litigation to the judge. Here an advocate is having the benefit. Most of the judges, they read the brief before hearing the case. Therefore 80% of the subject matter of the litigation is judge is aware. Only 20% the advocate has to canvass and to project before the learned judge. So start with the material facts of the case and followed by applicable provisions of law, and conclude the arguments with settled legal proposition on that given particular litigation. Now, there are other set of skills which are required during the course of submissions, which an advocate with due diligence and should exercise before the judge while arguing the case. One is, the advocate should not raise his voice, and he should be moderate and should not lose his temper while arguing the matter. Number two, whenever the judge interferes and raises any query or clarification with regarding to the submission made by the advocate, it is the bounden duty of the advocate to answer and to explain and clarify the doubts and queries raised by the learned judge. An advocate should not restrain or refrain or skip any query raised by the judge and should not continue arguing the case. This will lead to a negative perspective on the standing counsel, and the judge will not be inclined to hear the proposed arguments in the litigation, and judge will not have any clarity or the scheme on which the advocate wants to persuade his litigation before the learned judge. So it is always a cardinal principle that has to be followed during the course of argument is, an advocate first and foremost should listen to the judge's queries. Secondly, the advocate, while arguing the case, after completion of his arguments, should attentively listen the counter arguments by the opposite counsel. What happens when the opponent counsel raises a ticklish argument? Then advocate should well prepare to counter his arguments by making a candid submissions about his litigation. Therefore, it is advisable, while preparing the synopsis itself, an advocate should correspondingly should also notes, he should draw notes touching the counter arguments which are expected from the opposite counsel. If this exercise homework is done in chamber before coming to the court and commencing the arguments, so there will not be any disappointment or unexpected kind of submissions coming from the opposite counsel. Therefore, an advocate, before commencing arguments, he should make a research at 360 degrees touching all the legal aspects of the litigation so that he can effectively project the case before the court. And during the course of arguments, an advocate should also remember to maintain professional standards. An advocate, while arguing the matter, should not mislead the court or should not try to suppress a material facts or manipulate certain aspects of the case in order to get a favorable order from the court. All these unethical practices will create a bad opinion about the conduct of an advocate touching his etiquettes of profession, which will create a negative image on the counsel, and the learned judge will not have enough confidence to rely upon the arguing counsel and to decide the case fairly and properly. Therefore, it is highly advisable to follow the professional standard while arguing the case. The advocate, after arguing the case, he should ensure that he has delivered all the points which he has prepared in his chamber and nothing to be taken as granted, no stones should be left unturned, and to his utmost conscience and to his satisfaction, he should deliver what he has prepared during the course of arguments. And an advocate, while arguing the case, should always be focused on the particular submission which are very relevant and which substantiates the prayer claimed by his client and the relief which he should get from the court of law. So these are the basic elements which an advocate should practice in order to make an effective arguments before the courts.